All right, so we are now recording, and I will hand over to B for the first presentation.
Okay. Yeah. So can you see that? Uh, can you see that? Okay. Yeah. So my topic is the role played by clinical guidelines in medical negligence. So unhappy patients can do two things. They can complain or they can raise a claim. So most of my topic centers around a breach of the standard of care. So medical misadventures, you call them, there are about 500,000 of them a year in hospitals. And this is from the Australian Institute of Health and Welfare data. Due to the diverse biology of patients, background, morbidity, fatigue, workload, high turnover personnel, generally junior personnel around on weekends and nights with very thin supervision, a blame culture among the patients who said, this terrible thing has happened to me. Somebody has got to be blamed for this. Somebody has to be responsible. And doctors are at risk of becoming the second victim of litigation, even though each doctor is indemnified. That just makes them a litigation-worthy person for the other party. So as we've gone through this is regulation of medical workplace, just to note that, things are considered because medicine is one of the professions like law. But, when lawyers have a problem with professional misconduct, they're actually judged by their peers, which are other lawyers. But in this case, things are self-regulating, like the Medical Board of Australia regulates the doctors until something goes wrong. And then when something goes wrong, it ends up that the law becomes the final arbiter of what constitute proper conduct in a doctor. So this is my mind map showing the various components of it. Most of the time, as you can see, this is the complaint section and the criminal section. Then these are the stakeholders here, and these are the legislation that intersects with the case, with the performance. So as we can see, I had a case study of Gould and Southwestern Sydney local health district. An 8-year-old boy was playing in a canal one afternoon when a boulder crushed his thumb. On presentation, they gave him flucloxacillin after consulting with Liverpool Hospital, which is a big tertiary center. So the boy was transferred to Liverpool Hospital, had very delayed surgery, more antibiotics, and then the thumb developed gangrene and ended up being amputated. So as for the expert for the defense said that that was the proper antibiotic to be given because of this antibiotic therapeutic guidelines that were being followed. And doctors should not prescribe antibiotics upon a whim. So the judge did wonder, is this guideline? He had never heard of this antibiotic stewardship. He said, is it recent? Did it apply in 2011? Did it apply in emergency settings? Did doctors actually follow this guideline? They found that he disliked the expert witness. He was unduly dismissive of the clinical decision-making process, and he called it irrational. Now, as for the expert for the plaintiff, he felt that guidelines were just for junior doctors, and that senior doctors tended not to rely on them. And in this case, he felt that gentamicin should have been given. The judge concluded that from a common sense perspective, the guidelines were not mandatory and should be adapted to the situation. However, the Court of Appeal felt that the wrong legal test had been applied, and it was procedurally unfair as the plaintiff had not pleaded that the actions of the doctors were irrational, and the defense was not given an opportunity to answer this irrational charge. They felt it was open to the judge to prefer one opinion to another, but it would be seriously pejorative and rare to find that a practice supported by a large body of professionals to be irrational. So he felt that it did not reach what they call the exception threshold in terms of torts. the comment I can say is that, basically the expert witness for the defendant failed to explain to the judge that the antibiotic guidelines was a mandated policy guideline that the whole hospitals had to follow in order to secure accreditation. And that he couldn't tell the judge that the opinion held by the plaintiff defendant was outdated. And also because the judge and the experts were in such, different disciplines, that he assumed that the judge would understand what he was saying, but obviously he didn't. And it just makes you wonder that if the judge had actually worded his judgment somewhat differently, saying he preferred one opinion to the other instead of calling it irrational, it might not have been open to appeal. So guidelines are not new. They started, Plato mentioned it in 4th century, but it only more recently in the 1960s that it became based on research evidence. Before that, it was like beliefs, like you see this diagram here, there's hot, cold, wet, dry, water, fire, air, earth, and you try and balance these things like putting leeches on people to suck their blood and so on. So clinical practice guidelines, there are levels of evidence, which is written here, and judges actually do seem to understand that very well. And there's good evidence that they actually improve patient care. So however, there's so many guidelines around that nobody knows which one to follow. There are national, international, local, regional, even down to the individual department level. Even within the department, there may be different people following different guidelines. Now, as far as the administration is concerned, they divide policy documents into 3 types: policy, standards, and guidelines. And they consider policies and standards to be mandatory, whereas guidelines are not, right? But there are suggestions. Okay, so we're talking about the breach of duty of care. And so with respect to that, what we call the professional practice defense. So when can we engage this professional practice defense as a way to guard against liability? Okay, so it has to be something that is widely accepted. It must not be irrational, although there may be different opinions. Okay, so as you can see, the doctors think it's best practice and it will protect against negligence. The administrators think that's good, if everyone would do the same thing, and there's actually more risk mitigation. And the patient's view, actually, they would think that that's what was supposed to be done to me, and if it wasn't done, then something went wrong. Now, in the legal view, guidelines actually have no legal standing. They consider it to be hearsay evidence where the author of the guideline is not available to be cross-examined. Essentially, it's that. And therefore, it's usually introduced by the experts. So the expert would then need to convince the judge that this represents the standard of care. So expert testimony is generally based on the experience and knowledge of the experts. They tend to bring up any journal articles, if there are any, and guidelines. And because guidelines are generally supported by journal articles, because it's a codification of the existing research. So as far as the credibility, what I found from the cases I looked through is that the credibility of the expert witnesses require them to be working in the field. As current experience, there was one expert that was 82 years old and had not practiced for almost 20 years, which the judge did, take note of. Specificity is important. Let's say the defendant is a hand surgeon. You would ideally want hand surgeons to be on the expert panel. They need to be calm and not drawn into argument with the opposing witness. And they'd be less credible. In one case, the judge noted that this expert witness literally did nothing but go from case to case, being an expert witness, which was his job. So I did a survey online of all the medical negligence cases involving the use of guidelines using these various websites. What I did find quite late in the day was actually Lexis Advance is very, very useful. If you look here, if you search medical negligence and guidelines, so they present you with a whole page full of these items, and you can see the green ones is where medical negligence features within the case, and the blue lines are where guidelines feature within the case. And on the search page, on the search result page, you can just drag this across and it will show you the part where the guideline appears. And then you can decide for yourself whether you really want to open that document in order to read it. So that was very useful. So far I found about 26 cases. I have yet to finish going through the 160 results returned by Lexis Advance. So I might still find some more. So these are the things I found. Firstly, in the battle of the guidelines, there are very few cases actually where there were multiple guidelines in issue. And usually there's no problem with the experts deciding which guideline should be followed, or is the most authoritative one. And in the interpretation of the guidelines, the judge is guided by the experts, but ultimately he can decide against the expert advice. For example, there was one expert who said that I would have waited for a CT scan before I did a lumbar puncture and gave antibiotics, and the judge decided to disagree with him, and he said the guidelines say, oh, you should give antibiotics as soon as possible, within 30 minutes. And so he decided that he wouldn't want to wait for a CT scan to be done first from the patient. So so it turns out that he's actually reading the guidelines and deciding what they mean
10 minutes
for himself. Yeah. So, and as for application of guidelines, there are a couple of cases where involve nurses and paramedics, and for these people, it was mandatory for them to follow guidelines. So any deviation whatsoever would actually place them as negligent. For most people, it's not. All right. So there was articles on whether it was a sword or a shield. And it turns out most of us think that it'll protect doctors from getting sued, but actually it turned out not to be the case. In the vast majority of cases, the plaintiffs that won were actually showed that the doctors were not following the guidelines. So particularly if it was your own hospital guidelines, the court would expect you to follow that guideline that existed within your workplace. So following the guidelines actually was found to protect defendants. And departure of the guidelines actually did result in negligence. Now, there were a couple of cases of these planned deviations from the guidelines. So what happened was the guidelines said that this man is low risk for colorectal cancer and only required a sigmoidoscopy. But the surgeon had actually planned to do a colonoscopy, a more extensive examination of his colon. But what happened was he left, he was a locum, and then there was poor handover of his intentions, and as a result, the examination wasn't done, and he turned out that they did not detect his cancer, right? So they did find them to be negligent, even though according to the guideline, he didn't need more than a sigmoidoscopy. But because the doctor had already planned to do something more extensive and it wasn't done. So the other case was where the doctor actually planned to give the patient Clexane injection, blood thinner, but he failed to chart it in the medication chart, and the nurses failed to bring it to his attention or give the Clexane. But then they found that even if he had done so, he had charted it and it had been given, it would actually have made no difference to the case. And the guideline actually did not call for anything to be charted at all, did not require Clexane to be given in that situation. So he was found to be not negligent. So what we would not be able to know is what is the effect of guidelines on pre-trial conduct. because there was only one survey ever in America which surveyed attorneys and asked them whether guidelines actually influenced their decision to settle, which one quarter said it did, and one quarter said that it affected their decision whether to take the case or not within the last 1 month. So one quarter. So it may be that knowing what I found from analyzing these cases, it may affect pretrial behavior. Because as we know that most of these medical negligence cases are settled out of court. The problem, of course, that in Australia, it is not possible to find out this kind of information because settlements are generally confidential. And so nobody will really know why it was settled and whether the plaintiff decided to abandon their suit. So in conclusions, I can say that guidelines are seen as authoritative extrinsic evidence, a part of the expert evidence. It is important to follow the guidelines as it does offer protection, and actually it's more often used as a sword by plaintiffs. And there is a real need for a national body to endorse guidelines, revise and review guidelines. So.
Thank you. It's pretty much spot on time. Do we have questions? Before I throw my questions in. Well, one of the things is more of a comment than a question. I did like some of the terminology, such as unhappy patients and adverse events. I thought it's great the way these things get described. When something goes horribly wrong and you lose a limb, and it's like, well, I was unhappy that I lost that limb. It was up there with missing the bus in the morning, and it was an event that was adverse and a suboptimal event. But that's always the case when you've got a bureaucracy trying to recast things in language. One thing I think is really interesting is that concept of secondary victimisation, where someone's indemnified. Obviously, there's professional reputation things that becoming repeatedly sued may involve. That if it's known that you're sued repeatedly and the hospital settles every time, I can understand that could be bad in terms of gossip. But I do think it's one of the things that cuts to the heart of this issue, where it's not just an actuarial process, where it's not just a case of going, well, what are you worried about? The hospital's insurer is going to cover all the costs. All we want to do is provide a solution for this aggrieved person. And I can understand why the doctors in question arc up at that response. And I know, there's often cases where it's seen that they settle. Who knows why you settle? You settle for a lot of reasons. And part of it may just be to get rid of a case that's sort of damaging for the reputation of the hospital. Even if the hospital was always right, if it's like a child who's a victim or someone who's suffered a very adverse effect, there can be that issue of, well, we want to settle it because if this goes to trial and this is in the media all the time, it looks really bad, even though we did nothing wrong. So yeah, I was interested in the fact that the legal process doesn't really take that into account. And that seems to be a bit of a problem for the practitioners, that you can't take your ego out of it and just say, well, it's not my money, it doesn't matter. And I had a more technical question as well.
It's like this one where it says there's no smoke without fire.
Yeah.
So even though, like I said, who in the end remembers that Dr. Patel's case was actually overturned on appeal? Nobody does.
I know B and I have spoken about this as well, that one of the things that it just doesn't figure in legal analysis almost at all is the fact that there is a delay between decision and appeal. And when a case is reversed, there is a period of chaos and consternation that can often be years, that affects the people who are regulated by that decision. So we study law in a very historical linear sense, and we go, well, this was the case, but then it was overturned on decision. What we don't really think about is the 2 years it took for the appeal to go through, where people who are actually in society were under the trial ruling, and we're saying, well, what do we do with this? This how do we deal with this? And ultimately it was wrong. But I just think that is very interesting, and I'm not sure, and I haven't really seen this discussed much in legal analysis. Anyone else got any comments?
I just think it was very, very thorough. So it was just like boom of information, as in just, wow, there is a lot in this area that I wouldn't have even sort of thought of. It was just, yeah, very thorough. So very good, Bea.
Thank you.
And there's that advantage of being able to do a deep dive on a particular area, and just to see, rather than discuss something in generalities, to be able to go, well, what actually has been the thing specifically around guidelines in these cases? Some good planning at the start of the project in setting goalposts and boundaries, I think, is really paying off in terms of how interesting the results are. All right. Well, we might jump over to Ruby now, if you're ready to go.
So I didn't realise we needed PowerPoint presentation. I thought this was more of a discussion. So
you don't need one. You don't need one.
If you didn't realise I was having like an internal freak out, going, oh my God, where did it say PowerPoint presentation? So that's why if you saw me flicking through stuff, I was looking, going, did I miss something? So mine's more of just a general talk about my thesis, because I'm still working on it. I'm only about halfway through my draft, because I've hit things where I've had to sort of go, oh, okay, this is getting a bit big, I need to condense. And so I'm just getting to the guts of my draft now. So I've got about 3,000 words. So pretty much it's 10 to 15 minute talk.
Yep.
Okay, cool. So my topic that I'm looking at is child sexual abuse and why cases are being overturned in the appellate courts. So first I started doing more like specific on historical child sexual abuse. But the problem is a lot of cases, they're not just historical, they're also just fresh cases. So I had to bring that in to show the difference. So with my topic, to be able to look at why cases are being overturned in the appellate court, I had to start looking at the nature of the crime and the impacts that it's having. So one thing that seems to be quite an issue within this topic is when you get to court, there isn't an understanding, or there's a lack of an understanding of what's actually happening to victims with this crime, why they don't sort of behave what is considered normal, like other victims of other crimes would. So from the Royal Commission, it can be seen that, how do I explain this? So psychologically, victims don't behave normally as other sort of victims of crime. Not that you could even normalise it. But delay is very common. And also that, how do I explain it? So delay is common, and there are a lot of myths and misconceptions that are being put around in the court system. For example, that a victim would have what's called a hue and cry. So they'll come running out and going, this has happened to me. Again, it's not common, but these are being used by defence counsel. The types of questioning that's coming forward is, well, you had ample opportunity to say something. Why didn't you? And the answer is, it's the type of relationship which has many, many things. It's grooming, it's a personal relationship with the offender that prevents a person from coming forward until later in life when they have an understanding of what has actually happened to them. There are other things as well. For example, a continued relationship with the perpetrator. So if it's your father or your mother or a family member, you'll be asked, well, why did you keep speaking to them? Why did you keep having anything to do with them? And the courts just aren't seeing this as part of the crime. It's an attack on your credibility as a witness. So going from this, I guess, psychological exploration into the crime brings us to an understanding of why victims behave the way they do. Why then is this causing cases to be overturned? So I've then gone into, which I probably should have explained differently, offences. So I'm looking at then offences and evidence law. So I'm still doing evidence law at the moment, but I've got my offences down pat. So a lot of offences require particularisation. They and there have been, because of particularisation, there have been offences that have been created to try and overcome this. So, for example, offences such as persistent sexual abuse and course of conduct charges, that's in Victoria only, I believe. And then there's other offences that are used, such as indecent assault, grooming offences, third-party offences, and anyway, so from here, looking at these types of offences, of course, this builds up to why cases are being overturned. These are the offences that are being used. The issues with using these offences equals why cases are being overturned. So I explain what the offences are. So, for example, for persistent sexual abuse, it's usually 3 occasions. It reduces the amount of particularisation, as in you don't have to say exact dates, exact times, exactly where it happened. So it reduces that need for particularisation. And obviously when looking at defendants and their rights, so a defendant has the right to know the charges that are being put against them. And that's why there still needs to be some degree of particularisation. So through looking at these charges and then going back to the psychological, I guess, issues, it also comes into then you're looking at delay, you're looking at memory, you're looking at inconsistent testimony. So it's all, what I would say, it's all intermingled, it's all related, and it's everywhere. So I then move on to, after looking at the offences, I then start speaking about credibility, and I start talking about delay. So one of the biggest issues with this crime is credibility of the victims, because there is a struggle to particularise what happened, especially if you have multiple multiple instances of abuse. There's a case, I believe it's R and Johnson, it's a South Australia case from their appellate courts, and there is a quote that they talk about, that the more someone is abused, the harder it is to prosecute, and that it's a perverse sort of complex that the more you're abused, the harder it is to prosecute, because you would think the more acts, the easier it would be. So when looking at credibility, there's all this research from the Royal Commission, they've got research into memory, they've got research into eliciting witness statements, they're looking at, psychological reports. And this evidence has been there for a while. Like, it hasn't just been, it's not new, but it still hasn't translated to the courts. So from credibility, when you're actually in court, these things come up. They will ask you, you know, why don't you remember this correctly? And the delay, the report from the Royal Commission, which talks about delay, it shows that memory is not like a DVD. You can't just sort of press play and it's perfect. Memory is dynamic. It changes every time it's recalled. And this isn't being shown in court. There isn't an expert witness every time one of these cases comes forward. And maybe that's something that needs to be reformed. Maybe, you know, we need to have expert witnesses every time just to explain to the general public and to the legal profession that memory is not like this. It is not perfect. And especially for multiple abuse cases, because it is a repetitive cycle, the more and more it happens, the harder and harder it is to particularize, because it all begins to blend. It all looks the same. Usually you'll remember the first instance and the last, and anything that's significantly different in between. And this is shown in the memory research that the Royal Commission sort of paid for, you know, to find out, well, why is this happening? How do we understand memory? But again, it's not translating to the courts. So that's also part of delay. So that's sort of where I've written up to. And then from here, I'm going to move on to, so from all of this, how are we getting these verdicts? So inconsistent verdicts, uncorroborated evidence, so sort of those unsafe and unsatisfactory verdicts, judicial direction, which is another big issue, because judges will try and direct on reasonable doubt. They'll try and direct on delay. And then there's different types of, like the Longman warning and different warnings that are given about delay. And then you'll get cases where which is M&R, it's a High Court case, where they'll say, oh, well, we didn't have the benefit of seeing the jury and looking at the evidence because of credibility issues, delay, it's unsafe and unsatisfactory. And because we couldn't have the, what was the word they used? They used this really good word and I can't remember it. It's gone out of my head. But pretty much they didn't have the opportunity to see the witness in court, and therefore a jury should have seen a doubt and it should have been overturned.
That's 10 minutes.
So, okay, thank you. So from here, we're looking at, so these are the reasons why these things are happening, and I need to go into it a bit more specifically. I'm still sort of working on that. There's a lot of reports and things everywhere, and I'm still sort of collating it together. But from here, it's all about reform. So how can we fix this? And the biggest issue is we're an adversarial system, and I speak about this in my, I've already written it, in my thesis, that with an adversarial system, it is going to be very hard to try and change our evidence laws, the way in which we prosecute these cases, because compared to inquisitorial, adversarial systems can be seen very much as not really truth-getting. They're not trying to get to the truth. It's winning the case. You know, you've got the prosecution against the defence. How can we change this? We've been using it for hundreds of years. Now, the Royal Commission has said that they wouldn't recommend an inquisitorial system. So I'm not going to go down that path because I know we'd never be able to change that, even though it would seem like maybe a somewhat of a solution. So reform could be having an expert witness every time these cases are heard, because clearly societal values and the sort of, I guess, the legal community haven't quite met up to the research yet. There's still those myths and misconceptions that are permeating through the courts, and an expert witness can fix that. The other thing that can be reformed, they talk about special courts that are specifically for sexual abuse cases. However, this could cause special treatment, and that is an issue. Defendants' rights is another thing. But then again, you'll be touching on the rule of law and messing with that a little bit. And probably wouldn't work, but I'll still mention it as a possible solution just because of particularisation, but then again, it's sort of defendants' rights. And then the other thing would be for having decisions overturned because they haven't seen the witness, which is quite a common occurrence. They'll say, oh, well, we didn't have the pleasure of seeing the witness, therefore a doubt should have occurred. Why aren't cases being video recorded and given to judges in appellate courts so they can see the full case, see how the witness performed? Because really, that's the only evidence. In a lot of cases, there's no forensic evidence, no medical, it's just the witness. And that could solve a lot of problems. So there we go. I'm still fleshing it out, but that's so far what I have.
Excellent.
Thank you.
Thanks. Anyone got any questions, comments before I charge in?
If there's no one else, I guess I've got overall comments kind of from both of them. I mean, just listening to you guys talking about your topics, in both cases, I couldn't help but feeling like there's somewhat of a clash between the area that you're talking about and the law. And somehow something's not working here. And it's quite an extreme clash. I think with medicine, for example, I think that the whole area thinks in a different way. So then when you try and bring law into medicine, you always get a kind of a confrontation. And I guess in the case that Ruby's talking about, in a similar way, I suppose, you get the feeling that the law isn't really helping people who have already suffered. And isn't there some better way that we can come up with as a society to help people who have been injured in either of these ways? And I couldn't help also but think about some of the overlaps between what you're speaking about and the honours thesis that I was supervising last year, which Scott will remember too, which was about elder abuse and that difficulty which was explored by the thesis writer in where the person who's perpetrating the crime is also someone who's one of the most trusted people that you have, possibly. So this frequently happens with various different kinds of elder abuse as well. And so she argued that criminal law was not the answer to resolving that problem. I actually felt that criminal law did have a role personally, because I think it has an educative effect, even if people don't end up in the court. At least there might be some thought that this is just something that society really frowns upon. But in actual practice, it's either not going to happen because people don't want to drag their relative into court, or else if it does happen, it might mean the end of any sort of family relationship going on into the future.
Definitely. And especially what you were talking about with just the whole, that the law just doesn't, it can be very re-victimising. And it was commented in the Royal Commission that people want that justice. They want the justice from what was taken from them. And that's where I considered civil law. I considered the whole sort of, I wouldn't say, I'm not sure if it's restorative justice, but going down where you can get compensation, but it's not the same sense of justice of taking that person through court, getting the criminal record. So yeah, it's a hard line. It's a really hard line to find where we can balance these systems.
And I guess a lot of people who are not experienced in the law, who haven't studied it, might actually think that they're going to get justice through the legal system. And
strangely enough,
you know, they have a concept that if something bad's been done to them, somehow if they go to court, things are going to be solved. But quite often that isn't the case.
It's interesting in both cases how the adversarial system and the rules of evidence are problematic. That in both cases, the awkward way in which you've got to bring things into evidence. I mean, in B's case, in terms of having to introduce something that's clearly like a documentary piece of evidence through an expert as hearsay, is kind of mad. But also the the fact that the rules of evidence are built on what's been criticised for a very long time as a very artificial standard of the reasonable witness. And there are all those criminology studies that were done where you had people charge into classrooms firing guns and things, and then which are like, you imagine doing that today, and then you asked the students what colour jumper they were wearing, and you found that 60% of the students got the jumper colour wrong. There's been particularly in the 70s, a lot of attention paid to how unreliable witness testimony is of really more straightforward things where there's no relationship, there's no sexual abuse, the people who are witnessing are adults, and how just completely unreliable our memory is over the gorilla in the basketball court. Go on, I'm intrigued.
So that's one of the classic ones. They had a guy wearing a gorilla costume run across this basketball court during the game, and the vast majority of people never saw it.
So law then, not only in terms of like the directions that are given to juries is a big one, but the assumptions that underpin the juries are, what's going on if people can't remember? But the juries don't get access to this sort of information, that memory is very unreliable, and they are going to have to make a judgment call on it. So, it cuts against the entire adversarial system to say something like there should be standardized resources, that all jurors need to watch a 15-minute video on this topic, which would seem to be, from the inquisitorial administrative sort of approach, a much better solution. All judges have to be able to do this, that's standardized. This is going back to guidelines, isn't it? That when the judge gives a direction to the jury, we have a set of really firm guidelines. And I can see here where there's all these new offences and different standards and things, that judges are getting confused. And that's so lethal to due process, that it can literally be a situation where a judge just makes a mistake in giving a direction to the jury, and a very, very solid case then just dissolves into nothing. So, yeah, really interesting topics, both. I really enjoyed them.
And especially when it comes to, when you were talking about witness testimony, there's this belief that the more traumatic, you should be able to remember it. But that's actually not how memory works at all.
I suppose if someone came in and robbed your shop every day for a year, you'd remember what the person looked like, maybe. But this is a totally different type of offence.
But actually, they show that in very traumatic events, it's like the person protects himself by just not remembering it, especially for very young children.
Yeah.
They have like a memory block. But I wanted to say that, we've come across one or two cases of these child sexual abuse, and I don't know you ever get justice for anything, because this 12-year-old girl came and tried to kill herself by jumping off the Burnett Bridge here. Unfortunately, the Burnett Bridge is nothing like the Sydney Harbour Bridge. You can't die, actually, if you jump off of it. But she wouldn't know that, so she was totally unharmed. But, I felt she made a genuine attempt, but unfortunately the psychiatry people did not agree with me. And they said, she's not suicidal now, you can just send her home. And the reason why she jumped was because her stepfather, who was actually in prison for abusing her, was about to be released. And, and apparently her mother refused to go to the parole hearing to speak out against having him released. So you can see how complicated everything is. And now you're going to send this girl back to the house where she's getting abused by this person who's just coming out of jail.
It's one of those situations where there's just no good overall outcome. And it's almost like the legal process is almost about mitigation more than anything else. And equally, I mean, I don't want to be the I suppose being the devil's advocate, because memory is so unstable and so volatile. This is the sort of thing where you want to be careful of the risks of someone being convicted on the basis of something which was a memory that was not a true memory, particularly where you have therapists implanting. There was the entire satanic panic issue in the 1980s, where they found therapists were implanting memories of abuse, often in situations where it was impossible to have happened in the way that it did. And then you've got a question of, well, if you remember being abused because a therapist has implanted that memory in there, then who is the one who did the abuse? And there's a really sticky kind of situation where people's lives can be traumatized, including some of the a very famous case. I can't remember the name of the defendant, but he became convinced that he must have done the abuse and forgotten about it and repressed the memory of it himself, because this was at the height of the repressed memory before the American Psychological Association basically put the repressed memory thing down with UFO abductions and sort of where it belongs outside of clinical practice. But yeah, there were situations where the accused person became so enthralled by the idea of a repressed memory that they decided that they must have repressed the memory of doing the abuse and pleaded guilty to the offence. So yes, it's so tricky. And but I do think the I mean, it's clearly a fascinating topic. Being able to narrow your topic, and we can have a chat about that a little later. But getting it down to, I think, even potentially just the idea of videoing witness evidence for later appeal, which, let's face it, would probably be good across the board. That itself could be the whole focus of what you look at. There may not be enough in there, but there may be enough just to say, well, why don't we do it? And what are the counter arguments?
Definitely, because I don't know why it's not being done. It's easy. It's not a hard process. Yeah,
I mean, maybe we need to talk to some people who teach evidence or whatever to see if there's, or because I mean, I come from a human rights background and I can't think of any rights.
But they do it in America. I've seen it. You'll watch it on television that they've recorded the case, and you can see, how the witness performs.
Yeah.
So because it's not like in a transcript you'll see the witness cried. There's nothing. It's just what they say.
Yeah. There might be stuff written not in this particular context, but just generally about recording to have a bit of a squiz to look at. But yeah, I think that's quite interesting.
Definitely.
I mean, when I studied law, we were under the thrall of this sort of fetishization of the British, and anything that Americans did was fundamentally going to be a bad thing because it was American. But I was told you never ever cite American cases even as obiter, because that's just wrong. You only use English cases, maybe Canadian or South African or New Zealand. But
I think I've been told that too, because I've never cited one.
But depending on the field, I mean, there are people who do look at American common law and say, it's not binding in any particular sense, but it's persuasive. But that was really inflected. Michael Kirby, I think, is someone who broke the rules on that one, like he did on most things. But yeah, that was very much steeped in this idea of the British Empire and Australia being part of the British Empire, which fortunately has kind of disappeared largely from society. Some areas, I think it's still they still feel that. But the law used to be very, very kind of in that mode. So that might be a kind of a habit or a reflexive approach. We don't want the spectacle of justice and the blood and circuses of American style justice. But however, like non-televised justice that is just a recording for the purposes of appeal later on, I'm not sure there's any strong arguments about that, but I'll be interested to see if you do find any.
Yeah, definitely.
Okay, well, thank you, everyone. It's possibly just as well we're doing it over 2 weeks now, because we would have been really squeezed to put in 3 tonight. But thank you for your attendance. Any questions before we wrap up?
Could I speak to you after, Scott?
Yeah, sure. And I'll remember to stop recording.
So have you sent like the questionnaire? Sure. After this, I was going to work on the questionnaire.
Okay. I will put that on my to-do list for tomorrow. Okay. Well, I will stop recording now.